Hey there, or should I say, oyez, oyez, oyez. Today, let's talk about the U.S. Supreme Court. Everybody's doing it, so let's dive into a bit of the history and the background to better understand why the Supreme Court is so important.
Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
First, we can't move forward without reflecting on the legacy of the notorious RBG. So much has been said about the accomplishments and legacy of Justice Ruth Bader Ginsburg that I don't feel I can add anything that hasn't already been said. So I will simply offer a couple of observations. RBG, one of America's preeminent constitutional scholars and jurists, continued to carry a pocket constitution to her dying day. Why is that important? It shows her commitment to staying true to the document. But even more so, it shows humility and an openness to continue to learn, question, grow, and teach. RBG's story is one of triumph over adversity and discrimination. Her passion for women's rights was unparalleled, and her background and previous life experiences undoubtedly colored her rulings for the entirety of her 27-year tenure as a Supreme Court justice. Was she perfect? No, but she was committed to continuous improvement, both personally and in working toward a more perfect union. I would argue that humility, a questioning attitude, a steadfast focus on the fundamentals, and a commitment to making things better are the bare essential qualifications for a Supreme Court justice or any other American leader. RBG's story highlights that every human is subject to a myriad of influences and biases that color our judgments. While this is neither inherently good nor bad, it is something to consider. Do those biases make the person more driven to administer justice fairly and impartially, or do they serve a different master? All right, with that said, let's dive into the Supreme Court. The Supreme Court is at the top of the Judicial Branch, one of the three branches of the federal government laid out by the framers of the Constitution. Article 1 defines the legislative branch. The executive branch is spelled out in Article 2.
It's a thing called Article 2. Nobody ever mentions Article 2.
And the judicial branch is set forth in Article 3. Specifically, Article 3 of the Constitution establishes the Supreme Court. It allows Congress to establish other inferior courts, and it sets the precedent for lifetime appointments. I've talked a lot about compromises in my previous videos, and we can see one at work here. Why spell out a Supreme Court and then only vaguely mention the possibility of other inferior courts? In short, the newly forming states didn't want the federal government intruding into their affairs, but everyone could agree on the need for some mechanism to ensure the states didn't take actions that threatened the new nation. The compromise was to specify a Supreme Court and to let the rest of the federal court system get hashed out in day-to-day politics. Today, that federal court system consists of 94 districts or trial courts, 13 courts of appeal, and all these sit below the Supreme Court. So there are almost 800 federal judges with lifetime appointments today. All right, back to Article 3. The second sentence was all about judicial independence. The lifetime appointments would allow the justices to be guided by the law and not by what any powerful people or groups might think. Federal judges cannot be punished by removal apart from being impeached by Congress, and they cannot have their salaries cut. The framers seem to have thought through a lot, but there is much discussion today about the wisdom of lifetime appointments. Critics of lifetime tenure say that it causes judges to stay in their positions longer than they should, either because of age or just losing touch with modern times. They say judges should be appointed for a fixed term of years, say 14 or 18 years, with no chance of being reappointed. They still couldn't be fired, and since they would have to leave at the end of their term, they'd have no reason to shape their rulings in a way that pleases powerful figures or even popular opinion. But a change like this would almost certainly require a constitutional amendment, and the chance of that happening are extremely small. Okay, I've said a lot, and I haven't even said what the Supreme Court does and why you should care. In short, the Supreme Court is the guardian and interpreter of the Constitution. As the final arbiter of the law, the court is charged with ensuring the American people the promise of equal justice under the law. Their main limitation is that the court can only deal with cases and controversies. It means they can't cherry pick which laws they want to weigh in on. Someone has to come to them with a complaint first. They primarily hear appeals from lower federal courts and state courts, and they receive between 7,000 and 8,000 petitions for certiorari per year and hear about 100 cases annually. Certiorari is a Latin word meaning to inform, in the sense that the petition informs the court of the request for judicial review. The Supreme Court is the only federal court with the discretion to decide which cases it will hear. Justices consider the importance of a given case, and if 4 justices agree, the court will issue a writ of certiorari, which is a legal order for the lower court to send the records of the case for review. The Supreme Court also has original jurisdiction in a very small number of cases, and those are the ones that arise out of disputes between 2 states or between a state and the federal government. Okay, one common question is, why are there 9 Supreme Court justices? The Constitution doesn't set a number, and it leaves that to Congress. Originally, Congress set it to 5, and there were as many as 10 in 1863. As President Andrew Johnson was headed for impeachment in 1866, Congress decreased the number from 10 to 7, with the decrease to take effect as seats became vacant. This was to prevent President Johnson from naming any new justices. With only 2 seats freed up, though, by 1869, so 8 justices seated, Congress issued the Judiciary Act of 1869, officially increasing the number to 9, and hasn't budged since then. What are the requirements to become a Supreme Court justice? Well, none other than being nominated by the President and confirmed by the Senate with a simple majority. The last justice who did not attend law school was appointed in 1941. Justice James F. Burns didn't graduate from high school, but taught himself law and passed the bar at the age of 23. All right, why is the Supreme Court important? There's 4 main reasons. The first is finality. When the Supreme Court rules on a constitutional issue, that judgment's virtually final. The decisions can only be altered by amending the Constitution or by the court issuing a new ruling. 2, impact. From reproductive rights to freedom of speech to property rights to segregation, the Supreme Court has weighed in on every aspect of American life. The courts helped us answer questions like, can you burn a flag at a protest rally? Or can you not hire a woman for a job that might endanger her? The Supreme Court creates precedent that every other court in the country has to follow. This is meant to guarantee that the laws are applied equally to all people, no matter where they live. Number 3, transparency. Unlike the other branches of the government, Supreme Court decisions are written in opinions where the views of the justices are able to be read by all. We get to see not only the decision, but the rationale behind it. The justices and their team of clerks will publish majority opinions that set forth the ruling and precedent and inform precedent, but also concurring opinions that agree with the ruling but may differ on the rationale, and dissenting opinions that disagree on the ruling. All right, number 4, fairness. They're historically the fairest shot you've got. And I'm talking to you, my underrepresented friends. Usually, the Supreme Court has spoken up against discriminatory policies enacted by states and inequitable rulings by state courts. Have they always gotten it right? Ask Dred Scott, the enslaved African that sued for his freedom back in the 1800s, resulting in the Supreme Court ruling that blacks were not citizens of the United States. Landmark Supreme Court rulings have ushered in the end of segregation, vast improvements in women's rights, and great strides in LGBTQ rights. All right, so what is happening with the Supreme Court now? To date, the Supreme Court's been conducting business as usual, providing checks and balances to the legislative and executive branches as the framers of the Constitution intended. You could make a strong argument that the other two branches have gone off the rails, though. By dividing power between three branches, the Founding Fathers sought to protect us from any would-be kings or dictators. The president's executive powers would be limited by Congress's lawmaking and budgetary controls, and the Supreme Court's rulings on the constitutionality of laws and executive orders. The congressional checks and balances on executive power appear to have failed, with some congressional leaders no longer viewing themselves as representatives of the people, but rather as servants of the president. The executive, for his part, is increasingly showing traits of a fascist dictator, most recently refusing to commit to a peaceful transfer of power, one of the most fundamental hallmarks of American democracy, but also actively working to discredit the media, criminalize any opposition, squelch free speech, brood distrust in the electoral process, and spread misinformation. Furthermore, divisive and discriminatory policies are now emanating not just from errant states, but also from the executive and legislative branches of the federal government. From xenophobic travel bans to anti-LGBTQ military service restrictions to ongoing police brutality, the federal government has gone from intercedent to instigator. The president, in his own words, has described the urgency to fill the vacant Supreme Court seat.
Why he's rushing to nominate a justice to the Supreme Court, anticipating a battle over the election results.
I think this will end up in the Supreme Court, and I think it's very important that we have 9 justices.
I cannot emphasize enough how that is not the point of the United States Supreme Court. I can only hope that the Supreme Court justices would scream unconstitutional in unison, but suspect that it might be a 4-4 split at the moment. Since June, the Republican campaign has filed lawsuits against several states, including at least New Jersey, Nevada, North Carolina, Iowa, Pennsylvania, and Montana, seeking to prevent those states from making it easier to allow voters to cast mail-in ballots amid the coronavirus pandemic, which makes it more risky to gather at a polling place on Election Day. The president expects these legal actions, which amount to voter suppression, to escalate to the level of the Supreme Court if the 2020 popular vote doesn't go his way. This is to say nothing of blatant hypocrisy shown by members of Congress as they seek to serve the president's agenda by rushing to fill RBG's Supreme Court seat less than 50 days before the 2020 election, after setting precedent by blocking the previous president's nominee 9 months before the 2016 election. All of this heightens the importance of the Supreme Court as the only remaining functional check and balance on the other two branches. Is Amy Coney Barrett the right person for the job? I don't know. But I urge you to think long and hard about the motivations of those nominating and confirming her on what is sitting out to be a record-setting pace. Since 1975, the average time from nomination of a Supreme Court justice to a hearing has been 40 days, with a median of 42. And the average time from nomination to confirmation has been 67 days, with a median of 71. This appointment is a lifetime hire. There's no, you're fired. What's driving the rush to fill the seat? Consider whether Congress has the time to vet the nominee. Is a lifetime appointment worth the rush in 2020 when it wasn't in 2016? Is there a reason that the people can't be trusted to have a voice in 2020 when it was critical in 2016? All right, what can you do to help? Educate yourself. The more you know about the problem, the more you can be prepared to counter systemic racism, xenophobia, oppose racist and divisive policy. Don't blindly trust me or any other single source. Go to primary sources for information, such as supremecourt.gov. Cross-check what you find. I strongly encourage you to look at what the media across both sides of the political spectrum are saying and form your own opinions. This is all part of becoming information literate and being able to navigate this increasingly complex world. Number 2, participate in the ongoing U.S. Census. Being counted is one of the best ways to ensure you're represented and your community gets its fair share of resources. Fill out your census form. Encourage your family to fill out their census forms. Despite executive branch efforts to end the census early, as of Friday, federal court had ruled that census counting will continue through October 31. But don't wait. Fill out your form and stand up and be counted. The fate of the 2020 census may well be the next landmark Supreme Court ruling. All right, number 3, register and vote. This is important not just for the presidential election, but crucially for the down ballot state, county, and local posts that more closely affect the policies in your cities and towns. With 33 Senate seats up for re-election, this election presents an ideal opportunity to assert that the legislative branch is the representative of the people and not the puppet of the executive. Get involved in your community. Voting isn't enough. You have to hold your government officials accountable. You have to engage to ensure your community reflects your values, whether it's planting a tree, participating in a city council meeting, running for office yourself, or contacting your representatives. Your voice and your engagement matters. While there may be little that can be done at this point to prevent a rush nomination, ensure your congressperson and senator know where you stand. Let them know that we the people are watching. So, what's the verdict? It is my considered opinion that allowing the current administration to enthrone a crony on the Supreme Court will tip the scales fatally in favor of American democracy's fall to fascism. If you agree with me, we have to do something, so let's go. If you don't agree with me, thank you for listening and considering my views. I guess things are going pretty good from your perspective. In either case, I hope to hear from you. Much like the Supreme Court, you can concur with my ruling or provide a dissenting opinion. Until next time, be safe out there. It's a beautiful and dangerous world.